I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments, and coming off of a huge week last week and a big Friday night. Everything that happened out in Kenosha still reverberating tonight. We're going to talk about it a little bit later. But right now, here we are now in closing arguments in another huge case in Brunswick, Georgia, the shooting death of Ahmaud Arbery. 3 men on trial for murder, all facing life in prison. Today, the closing arguments in this case. And this is a case also that involves an allegation of self-defense. That's part of the defense here, self-defense. But we are really sitting here with a much different situation. And I just want to take a step back, okay? Yes, we're going to dive into the legal standards and the specific facts of the case and really get into the weeds. But I want to take a step back because from my experience, you need to take that step back in a self-defense case. Because that visceral reaction that you have to a situation, I think, is the same visceral reaction that a jury has. You look at a death, a shooting death, and you look at it and you say, okay, well, someone is alleging self-defense here. Well, who started it? Who started it? That's not a legal standard necessarily in those words, but I think that's the way most of us look at these self-defense allegations. I think it's the way many jurors approach them as well. You know, there's a confrontation, someone is dead, the person who killed the other person is alleging self-defense, but wait a minute, who started this whole thing? And we know what the jury found in Kenosha, and it was consistent with what the video showed us. That yes, there were people. Everyone shot by Kyle Rittenhouse was chasing Kyle Rittenhouse. Everyone shot by Kyle Rittenhouse initiated the confrontation with Kyle Rittenhouse, as shown by the videos. Let's move to Brunswick, Georgia. What do the videos tell us? Who's chasing who? Who's initiating the confrontation? Who is starting this whole thing? And I think that's important, an important distinction. Now, let's break it down. Get into the weeds, okay? For the defense here, there's really 2 huge hurdles they need to get over. You don't start with self-defense. First, they've got to justify this chase because it's clear on the video who's pursuing who. The justification, the alleged justification in this case for the chase is the citizen's arrest law. And that was argued today in court, both sides in front of the jury. In closing arguments, take a listen. I'm going to play for you the prosecution, then the defense.
Citizen's arrest. This was not a citizen's arrest. Not present when any crime was committed. The suggestion that Ahmaud committed a crime is based on what? Not immediate knowledge, speculation. Speculation. How do we know? Because of the defendant's own words to the police. That's how we know. Wanting to question Ahmaud demonstrates uncertainty. Hey, where are you coming from? They don't know where he's coming from. What are you doing? They don't know what he's doing. Remember, Mr. Bryan? Heard, what'd you steal? Okay? They don't know what he's done. They don't know why he's out there running. They don't have immediate knowledge. They have no knowledge. They have speculation because he's running down the street. Wanting to question Ahmaud demonstrates a lack of immediate knowledge, which is required under the citizen's arrest law. Because it's required, that means this was not a lawful citizen's arrest.
Travis had all of this. His reading Facebook, everything going on at Larry English's house, knowing about what was happening in Satilla Shores, speaking with everybody on the 11th, his own experience, Albenzi signaling, Officer Rash and Matt Albenzi. This is what he carried with him when he left his driveway that day. Reasonable and probable grounds of suspicion. Reasonable and probable grounds of suspicion. Facts and circumstances to warrant a prudent person, one taking care to understand the truth. In believing that the suspect has committed the offense of burglary. Travis believes he's committed the offense of burglary. The facts necessary to establish probable cause for arrest are less than those required to prove guilt beyond a reasonable doubt. It's more than suspicion or possibility. It's got to be a probability, probably. And he said, I had a probability. There was a probability that this was the guy who did it, and here's why I think he did it. And I wrote down every one of the things that we talked about as he testified. I wrote them all down, and they are all encapsulated in that slide I just told you. This is where the duty and responsibility in following the law becomes intertwined with heartache and tragedy. Because you do have the right to perform a citizen's arrest. You do have the right to have a firearm when you make an arrest. You do have the right to stop a person and to hold them and detain them for the police.
Okay, as you know, there are, in cases, in trials, there's the facts and there's the law. Sometimes you argue the facts, sometimes you argue the law, sometimes you argue both. I'm trying to really focus in on where the difference is and what this jury is going to have to figure out as it pertains to citizens' arrest. So I've got to bring in Court TV legal correspondent Julie Janae, who's in Brunswick, Georgia tonight. She knows all the facts of the case that both sides have argued. She knows the law. So let's start there, Julie Janae. Are these two sides agreeing in their arguments as to what the legal standard is? Is it just that they're arguing a different interpretation of the facts here? Explain to us the difference between what prosecutors are arguing to this jury and what the defense is arguing as to citizens' arrest.
Vinny, there is a difference in their interpretation of the law. So not even getting into the facts, but when we're looking at the citizen's arrest statute and the two prongs that are required there for understanding that a crime has occurred, it has to be either in the presence of or in the immediate knowledge of. So one or the other. The state views this as one and the same, and they gave the description today or example of a security guard who is yards away from where the shoplifting is happening, but they are looking at screens and monitors from the security camera, and they have immediate knowledge that someone has stolen something because they see it, but they're not in the presence of. The defense, however, says it's not one and the same, that in the presence of is when you physically are there and you see a crime happening, but immediate knowledge can be at a different time, and it can be that you have probable cause from other information that you have gained, and that is still part of citizens' arrest. We even heard Franklin Hogue, the attorney for Greg McMichael, today standing up in the middle of the opening or closing argument, rather, for the prosecutor to object when she was explaining to this jury that those two prongs are one and the same.
So what is the judge going to tell the jury about this issue? Because that's who they're going to look to ultimately for guidance, right? Jurors trust the judge. That's the judge's job. What is this judge going to tell the jury about who's right? Is it the prosecution or defense?
You know, the jury is going to get these instructions, and they're going to get a citizen's arrest statute that is going to read, just as I said it, immediate knowledge or in the presence of. They won't necessarily get a definition of immediate knowledge. They will get that contemporaneous arrest instruction, and we understand it's been modified some over the weekend, where the prosecutors wanted to tell this jury that any immediate knowledge or reasonable, probable suspicion has to come at the same time of the crime that's being committed, and someone has to carry out that citizen's arrest right away. They can't wait until later. But our understanding from the defense attorneys is that the language has been modified to allow this jury to take into account, or see it from the defendant's perspective, that they are allowed to take into account other things that have happened prior to, which is important in this case because Travis McMichael had that encounter with Ahmaud Arbery 11 to 12 days before the actual incident of the shooting, and he wants to be able to use his understanding and the things that he learned 12 days before as to why he was trying to carry out that citizen's arrest on February 23rd, 2020.
This is so incredibly huge. And it seems to me we're almost asking, in this instance, Julia, the jury is making an interpretation of the law to a certain extent.
You know, they looked at the judge when there was that objection by Franklin Hogue about, and he said, I don't usually like to interrupt a closing, but this prosecutor is misstating the law. She's not accurately telling this jury what the law is, and asked the judge in front of the jury to tell them that the instructions are going to come from the court. So the jury knows in that moment, if they're paying attention, which they really were, Vinny. I was in the courtroom today just seeing how engaged and attentive most of them are. They will know that this part is really important, and we're going to have to be paying attention to these jury instructions to figure out what that's going to mean and what it looks like. But it may come down to some things that they have to interpret based on what they've seen and what the letter of the law is.
Wow. Okay, let me bring the think tank. Don't go away, though, Julia. Joining us tonight in Los Angeles, California, Deputy Public Defender for Los Angeles County, Philip Dubé. In Minneapolis, Minnesota, Criminal Defense Attorney Joe Tamburino. And in Atlanta, Georgia, Criminal Defense Attorney Michael Bixson. Great to see everyone tonight. Michael, I have to start with you, Michael Bixson. You're in Georgia. You're on the hot seat right now. You are on the hot seat. To me, this is...
lucky me.
We are in a position here where the prosecution and defense are disagreeing in front of the jury in their arguments about what the citizen arrest law is in Georgia. What is this jury supposed to do?
I think they're going to have to wait for the judge's final instructions. And let's be clear, this is a really poorly written law, and it's not the only one. I mean, it happens all the time. You read through all the statutes and you look at them and you go, my God, who wrote this? and this is definitely a problem with this one as well. I mean, it's since been repealed, but what they're dealing with in court now is a very poorly worded statute. And because of that, it's rife for misinterpretation and a lot of issues. And, obviously if there's a conviction, maybe appeal. But I think eventually the jurors are going to have to learn to listen to the judge in terms of, how the judge describes the statute and his in the instructions in which they'll take back with them when they're actually making their deliberations.
Philip Dubé, if this jury believes that it's in the immediate knowledge of, it seems clear to me, I don't know if it was in their own minds, they had all this knowledge that something was going on, that he had been in the house several times. Will that be enough to get over this first hurdle? I know there's two hurdles for the defense, but do you think that's enough to get over the first hurdle, that somehow this jury may think it's a reasonable argument that this was a lawful attempted citizen's arrest?
I think it's going to be a problem, and I'll tell you why. Probable cause cannot ever go stale. It has to be fresh at the time of the pursuit. You don't get to factor in past activity that could, somehow play into your determination or into your strong suspicion that a crime has been committed. You have to look at that moment in time. And frankly, the defense should have asked for a pinpoint instruction for the jury to define probable cause, and that is a state of facts, if you will, that would lead a person of ordinary prudence to believe and conscientiously entertain a strong suspicion of a suspect's guilt of a crime. And the way this instruction is written and the way the statute is written, they don't really define probable cause. So I think that's what they need to focus on. What state of facts would an ordinary person, if you will, standing back objectively, rely on to say, I believe Ahmaud Arbery has committed a crime? And I think that's where they need to focus their attention.
Joe Tamburino, if this, let me change things just a little bit, right? Hypothetical, here we are. This is a tough legal question. If a police officer had seen all the videos and had heard from English that, yes, some stuff had been stolen from my place, and to me it seems like this would be, this is the guy we've been looking for, the guy from the videos. Is that enough? Would be enough? Is there any difference? Would it be enough for police versus these citizens trying to effectuate this citizen's arrest? These wannabe cops of the neighborhood, the McMichaels. Is it enough here for probable cause, knowing that, hey, that's the guy from the videos?
It might be enough for a trespass, but not a burglary, not a felony. And I think, Vinny, what you hit upon is really important. These guys aren't cops. They're citizens. Police can go back in time and develop a full case. And
So
develop
you're saying there's a
probable
difference.
cause.
You're saying there's a difference for this
Absolutely.
probable cause standard for if they were police officers versus citizens.
Absolutely. And that's why the citizens arrest law in Georgia at the time, which has since been rescinded, clearly states it has to be in your presence or immediate knowledge. It doesn't say in your presence or after you as a citizen conduct your own investigation and can go back in time 6 months and build a case. There is a difference between being a licensed police officer and being a citizen. The citizen arrest laws, what the defense is doing in this case is they're really trying to stretch it and drive a truck through this. I don't think they have a case. I think this is the best that they can do. They clearly were acting outside of the citizens defense law. Arrest law, and even when we get to self-defense, they were clearly provoking the
We're
situation.
getting there. You almost did my tease for me, Joe Tamburino. Look at that. Stepping ahead. That's good. Because this is the first hurdle. There's a second hurdle, which would be the self-defense. We're going to talk about that when we come back and get more insight from our think tank with us the whole hour and Court TV legal correspondent Julie Janae. We'll be right back.